rise. Court of Appeals Division 1 is now in session.
Thanks. Please be seated. Good morning. We're here for oral argument in case number 1, CACV 16-0651, Maricopa County Sheriff's Office versus Walter Duncanson. Council would remind you that this oral argument is being video and audio recorded, so I'd ask you to please identify yourselves and your client at the beginning of your arguments. Each side will have 20 minutes. So counsel for appellant, if you'll watch the clock and monitor it and reserve as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs and discussed the case in conference, so we are familiar with the facts and procedure. And with that, counsel for appellant, you may proceed.
Thank you, and may it please the court. I'm John Willencheck for the appellant, Walter Duncanson, and I'd like to reserve at least 5 minutes for rebuttal. I think we've got a very clear error in this case concerning one of our favorite issues here in the Court of Appeals, which is the standard of review. The lower court committed clear error by applying the wrong standard of review to a decision of the Merit Commission in this case. The lower court, instead of applying the proper standard of review, which is deference to the Merit Commission on an issue of fact, instead appears to have reversed that standard of review and said that the Merit Commission was at fault for, quote, ignoring substantial evidence. That's the exact opposite of the proper standard. The proper standard is if there is any substantial evidence to support the decision of the Merit Commission, then its decision must be upheld. I can only speculate that the confusion here for the Superior Court was that, as was announced by the Arizona Supreme Court in Juarez, there is a two-step process for the Merit Commission in reviewing any employer action, which is what it's in the business of doing. The first step is to determine the facts and establish a factual record to determine the, quote, essential facts of the case. This step is something that the Merit Commission does de novo, and it does to a preponderance of the evidence standard. And after it's done so, the Superior Court must defer to that finding, again to an arbitrary and capricious standard. If there's any substantial evidence to support those factual findings, they must be upheld. Again, we have the opposite problem here, where the Superior Court instead said, well, I think that the Merit Commission, quote, ignored substantial evidence, and therefore I'm reversing. I can only speculate the Superior Court felt like the Merit Commission had an arbitrary and capricious standard to the employer here, and that's why the Superior Court ruled that way, but that's incorrect as a matter of law. The Superior Court was obligated to defer to the Merit Commission on its factual findings under an arbitrary and capricious standard. Once the
one
yes,
of
please.
the problems we have here, and I know you're aware of this, is the Commission made a specific finding that, as to what I'll call the child custody incident, your client violated various policies. And so it makes that specific finding, cites the policies that were violated, and makes what seems to be an irreconcilably contrary conclusion then that MCSO didn't prove a violation. What do we make of that?
Right, thank you. And with all respect shown to the Merit Commission, in their final ruling, there's a reference to how they're incorporating the comments they made at their September hearing. I wish they had written those comments out, because they do require reference to the actual audio of the hearing or the minutes of the hearing, which reveal, and we liberally quoted from in our reply, but they reveal that the basis for that was this idea of a disciplinary matrix. And of course, we're here to get into the weeds, so I'll go ahead and get into the weeds on that. So the committee found, and during deliberations, one of its members said, the commission found, that I only find one of these two incidents happened. And, you know, for convenience, we'll refer to them, as I believe the court just did. There's the report incident, the traffic stop incident. So during deliberations, one of the committee members says, first committee member to speak at length says, well, I find the report violation happened, and that became part of their findings of fact. But he says, I don't think the traffic stop violation happened, and therefore that did not become part of their findings of fact. And he then said, based on only one of these two things happening, I think that the discipline imposed, which again was originally imposed for two things, was inappropriate for just the one thing. And he said, quote, that it did not line up with the disciplinary matrix. The disciplinary matrix is just a chart that the sheriff's office, the employer here, the appellee, puts out to show what's the permissible range of discipline for any given offense. And there's a lot of discussion about that at the hearing. Certain concessions were made, even by the MCSO, that this did not constitute a, quote, grave offense under the chart. So the conclusion this committee member who spoke at length during the deliberations his conclusion was that the one incident fell outside the disciplinary matrix. He was asking them even prior to the deliberations when he was questioning the counsel for the MCSO. He said, well, do you consider this a grave offense? He said, no, it's not a grave offense. That's significant because under that chart, only a grave offense gets the maximum penalty. And this was either the maximum penalty or somewhere beyond the maximum penalty on that chart. So the commission member said, again, in deliberations, he says, I don't think this lines up with that matrix, i.e. it's outside of the permissible range of discipline. And therefore, just the one offense was not enough to sustain a demotion. So I know it's a long, complicated explanation, but the simple explanation is there were two things here. The commission found only one of them happened. And the one thing that happened wasn't enough for demotion, even under the MCSO's own chart, even under its own disciplinary matrix.
Why would that be so? Because let's go with that for a minute, that only the, what you call report incident, I call the child custody incident, either way, was sustained. Under the matrix, if that was Category 3, which encompasses conduct that has a pronounced negative impact on the operations or professional range, as well as conduct that falls within a lower category but is repetitive in nature, why wouldn't it, given the Chief Lopez's testimony that one incident would have been sufficient for demotion, why wouldn't the record still support the Superior Court's ultimate decision?
Because, first of all, there was a dispute about whether it was a Category 2 or Category 3, but even if it were a Category 3, the maximum for Category 3 is denoted as that 80 hours. And then there is a note at the bottom of the chart that says for 80 hours the motion may be considered. But then on the second page of that whole policy, there's a lot of discussion, again, in the record with the Commission where they're saying there's a definition of grave acts, and basically says do not impose the maximum unless it is a, quote, grave act. Otherwise, you should impose the lowest possible discipline. And the MCSO conceded this is not a grave act. So therefore, it's not the maximum of 80 hours, and certainly not the super maximum, I suppose, of a demotion. So that's why the commission member was saying, look, this is excessive. This is beyond even their own chart. This is arbitrary and capricious. It's not even at the maximum or the super maximum, as that footnote says, that, you know, for an 80-hour thing, a demotion could be imposed.
There's a danger in relying too much on the comments made during deliberations. First of all, they're all over the map, and the same commission member who you're talking about who didn't find a violation for the traffic incident said basically, and this is a quote, it is a discretionary call for someone to say if he did enough here. I mean, that recognition to me undermines the notion that the hiring authority was arbitrary and capricious or didn't prove it. I mean, I just think we go down a dangerous path in relying on all these deliberative comments, and I got to tell you, reading and listening to some of that made my head spin, because we have lip service to Juarez, but there's a lot of undercutting of Juarez in that whole discussion.
I have two responses to that, if I may. First, I'm aware of that comment that he made about how it's a discretionary call. I think it's important to distinguish when he's talking about a discretionary call in terms of the facts, in terms of whether it was misconduct. Because that, again, is this issue of preponderance of the evidence, you know, finding what the facts are, whether misconduct even occurred. He wasn't saying discretionary call in terms of how much discipline is imposed. I would agree with you if that's what he was saying. We've got a Juarez issue. Because the facts are there, nobody disagrees about the facts, and it's just a discretionary call about how much discipline. His comment was in a different context. He was saying it's the discretionary call whether Sergeant Duncanson had to stand closer to this person in the car or not, whether that was even misconduct. That's the context he was saying that in. So he wasn't saying that's...
I actually agree with you. I think that is the exact context in which he was saying it. But then doesn't that to some extent undermine the notion that there was no violation? If it's a discretionary call, if reasonable minds could differ...
That's where it's so important we have this preponderance of the evidence standard for fact-finding, as opposed to an arbitrary capricious standard. If it were an arbitrary capricious standard for fact-finding, I would agree that's problematic. If he's saying it's discretionary, it could go either way, therefore you have to defer to the employing authority. But we have, under the Juarez decision, this preponderance of the evidence de novo standard for the Commission in determining facts. So that's where the Commission gets to say, look, I think that didn't happen. I think that there was no misconduct there, and we don't owe any deference to the employing authority on that note. I'd like to respond to another issue on that, unless you have further questions along that line,
Thank you.
which is, there is this issue here, too, floating in the case of, well, were these findings sufficient? Were there sufficient legal findings or even factual findings? I think our clear position on that is, to the extent this could have been a better final decision from the Commission, incorporating very clearly its basis, that kind of thing, instead of just saying we hereby incorporate our deliberations and comments made at the meeting. The clear remedy there is not to reverse, it's to remand, and to allow the Commission to clarify itself. I think it's just a matter of basic fairness, and because otherwise, it's just allows the Superior Court to substitute its decision for whatever it wants the decision to be. If there's any issue there with clarity, the clear remedy is to remand, it's not to reverse. The final thing I'll bring up in response to that, to Your Honor's question, is this is very distinguishable from Juarez in general. And I think we probably all understand that. But, Juarez was a case where there's no dispute about the facts. And it says right in the beginning that the discipline was based on, quote, undisputed facts. And it was consistent with MCSO policy and practice. So it was just this dispute about whether the discipline was appropriate or not. This is a wholly different case. Here we have a dispute about facts. We have a dispute about whether it's consistent with MCSO policy and practice. We have that, again, same Commission member saying during deliberation that this is inconsistent with other cases that have gone before the Commission, which raises this notion of the Commission having certain expertise in dealing with these kind of cases. He said, we've seen other cases where they were much worse than this. It was only a 20-hour suspension. So we have a case here that sort of falls in, I think was predicted by Juarez. This case where you've got disputes about the facts, and you've got a dispute about whether it fell under their policy and practice, whether it was in the permissible range. So very distinguishable from Juarez, but that's the case we have in front of us here today. So, at the end of the day here, I think we've fairly addressed the main points here. There's been an issue about waiver. I don't think waiver is at all applicable here because at the end of the day, we're defending I'm defending, and we're talking about the decision of the Commission. I don't see how the Commission waives its own basis for a decision, whether or not we raise it or what time we raise it, in defense of that decision. But we have raised all these issues before the Superior Court, specifically talked about the matrix and all of these issues. So at the end of the day, I think we have to concede, just as a matter of basic fairness, that this could have been a clearer ruling. Probably would have saved us a lot of time here instead of having to listen to half an hour to an hour worth of deliberation and audio recordings, to have had a very clear ruling that spelled out the basis for this. And I can see how the Superior Court struggled with that as well. But again, the obvious remedy there is to remand the case. It's not to reverse it. I think unless the Court has further questions, I'll reserve the rest of my time.
Okay.
Thank you.
Thank you, Counsel.
May it please the Court, my name is Joe Branco, here on behalf of the Maricopa County Sheriff's Office. This Court should affirm the Superior Court's ruling because the Merit Commission exceeded its narrow and deferential role to review discipline imposed by the Maricopa County Sheriff's appointing authority. The appointing authority disciplined Duncanson for 2 offenses, and Judge Downing has already gotten to the heart of the matter, so I may as well get there as well. The Commission teed up, through its findings of fact, one of those 2 offenses. It was an offense that Deputy Duncanson admitted during the course of the discipline proceedings. It was one that the Merit Commission found sufficient facts and even had a conclusion of law. I think it's the 3rd conclusion of law that says there was a violation of policy here. And gets to the end of its order and says, well, actually, the respondent didn't meet its burden of proof, and actually it's arbitrary and capricious. It's inconsistent. Again, set aside for a moment what occurred in the traffic stop. The child custody offense alone is enough to demonstrate that there was a need for discipline here. And Juarez talks about how a Merit Commission cannot come in the back end when there's a demonstrated need for discipline and say, well, we're uncomfortable with the level of discipline. In this case, that's exactly what comes through in the hearing, no transcript, which I think is telling, instead on the audio recordings, that they were uncomfortable with the fact that he was demoted for this. It's very difficult to tell at times who is speaking. People flip-flop back and forth on their position. One of the commissioners, who I believe ultimately voted in favor at one point, is talking about Robert's Rules of Order and about how he's going to vote in favor of it because something happened here. It's very confusing. That's, of course, why Merit Rule 11.14 requires written orders. And the written orders in this case, which is part of what the Superior Court relied on to demonstrate that there was substantial evidence, the written orders demonstrate that at least one of the two occurred. And I would submit that the written findings of fact also demonstrate that the second offense occurred. The only way that the Merit Commission can get around the second traffic stop offense is to substitute its judgment about what Deputy Duncanson should have done in the moment, where you had Chief Lopez, the appointing authority, the disciplinarian, talking about what he expects, what the office expects a supervisor to do when someone is actively resisting arrest in the back of a squad car, where the husband is able to roam free. And in the video, the husband actually shows up directly behind one of the two deputies who's putting on the leg irons. And so it wasn't simply the distance. This is kind of a red herring that appears both in the hearing itself before the hearing officer that Deputy Duncanson raises. It appears again for the Merit Commission, and it appears very strongly in the reply brief. This idea that there was no written rule, no written policy about the distance that a supervisor needs to stand from a subject's vehicle, or in reality, in this case, it was the squad car. The distance wasn't dispositive for Chief Lopez or for the investigator.
It had nothing to do with the subject's vehicle, which it was their finding of fact, correct?
Yes. And so that's one error, and I assume it was an error of omission rather than commission there. But they were in the squad vehicle, and it was not just the distance. It was the fact that he was behind the Tahoe. He stayed on the phone. At one point, it came up in the hearing transcript, well, what would you have him do? Hang up. Help out. It wasn't simply a matter of, there was another issue raised in the hearing about, it seems like an awful lot of people to be getting into that squad car. I think one of the commission members even said, well, I've never been a cop, but no, that wasn't it. It was also officer safety, which is revealed on the video. This is objective evidence.
Let me ask you what I also asked Mr. Willencheck. The one commission member who voted in favor of overturning the demotion said in connection with that incident, it's a discretionary call for someone to say if they did enough. And when I asked Mr. Willencheck that question, I think, he pointed out that the issue here was their fact-finding as opposed to whether it was arbitrary and capricious for MCSO to believe that's a violation. Talk to me about whether that statement sheds any light on the issue.
I think it does, because I think that it's a results-oriented adoption of that extra finding of fact. I think that what becomes clear in listening to the audio recording is that they were unhappy with the result and tried to use the findings of fact as the way to sort of massage into place overturning the discipline. And so acknowledging with the one hand that it's a discretionary call about where a supervisor needs to be when a use of force scenario is playing out, or where a traffic stop starts to go sideways, on one hand, and then adopting this very narrow and kind of odd 18th finding of fact that talks about a non-existent rule. Again, Your Honor, you said pays lip service to Juarez, and I think that's exactly what's happening here. The Merit Commission can't use its finding of fact power, which does deserve deference, of course. Not absolute deference. Juarez makes clear that when the record, and of course it's also in the administrative review by statute, when there's substantial evidence in the record that what they found was incorrect, a court doesn't have to turn a blind eye to that, and thankfully the Superior Court did not in this case. But when it's discretionary like that, it really is getting toward a conclusion of law or toward a conclusion of the appointing authority about what the the supervisor should have done in that scenario. One of the arguments that appellant just made was to try to explain how they could still reach that result. And there was some discussion. Appellant relied on the discussion about the discipline matrix. There was some discussion on the audio recording about the discipline matrix, but that was never written down pursuant to Merit Rule 11.14. It was never even voted on. It's almost tantamount to listening to this audio recording later on YouTube and relying on the questions that the court asks to try to discern what was meant because the court left it out of its written opinion. It doesn't work that way. There was an opportunity to vote on it or discuss it during the voting or have it written down in the order, and they didn't do that. And it's not simply a matter of, well, send it back down to them and have them clean it up. There's nothing to clean up. Again, the first offense, the child custody offense, was admitted, confirmed by the findings of fact conclusions of law, and undisputed on appeal. Twice, once in the opening brief, once in the reply brief, they acknowledged that the Merit Commission made those findings. That's sufficient by itself to uphold the Superior Court and put that demotion back into place.
Counsel, let's go back to the matrix.
Yes.
That's a little confusing to me. So explain to me, give me your best shot on why was the demotion justified under the matrix?
Okay.
Because counsel referred to some nuances of the chart, and help me understand that.
Sure. So if you look at page 2 of the discipline matrix, it talks about progressive discipline. And progressive discipline is something that the Merit Commission is required to understand by statute. Progressive discipline is this idea that, of course, you don't jump automatically to firing or demoting, or you have to take progressive steps, incremental steps along the way. And that's exactly what happened in this case. There was prior discipline that was imposed. It was a 32-hour suspension. And it was actually prior discipline for failure to closely monitor subordinates. In that case, it was a homicide investigation. And so when counsel brings up the grave acts exception, the grave acts exception has nothing to do, at least per the terms of this policy, has nothing to do with where within the range of discipline someone falls. It has everything to do with the idea that grave acts are the exception to the progressive discipline rule. That's why it's actually under the title progressive discipline, so that if someone commits something so horrendous, so egregious that's a violation of policy, even if there have not been previous disciplinary proceedings or previous discipline either on that issue or on another issue, they can jump up the matrix in that way. When you turn to the matrix itself, if you'll excuse me a second, I left my water.
Yes.
Well, and let me maybe hone in a little bit, because I think to sustain the demotion, this had to fall within Category 3. Would you agree with that?
Yes.
Okay. And so no finding was specifically made, I understand, because it wasn't specifically litigated whether this was a Category 2 or Category 3, but what in the record would allow us to say, yes, this falls within Category 3?
Two things. So number one, there's the predetermination worksheet that the appointing authority utilized, and that was where you get the Category 2/3. When you turn to Category...
The record, do you remember?
It is... I apologize. I don't have that. It is in the same general section as the letter. So if I recall correctly,
The letter from Chief Lopez?
So there's the initial letter, the predetermination letter, and I think it would have been right after that, because I think that section of the record is in kind of reverse chronological order.
Okay. So that's where the 2/3 comes from.
Yes, that's where 2/3 comes from, and I believe it's referenced on either pages 19, 20, or 21 in the answering brief as well. And unfortunately, I didn't do the court any favors by splitting up this explanation in those two subsections. So you get Category 2/3 from the predisposition worksheet. You also have Chief Lopez's testimony that either offense would result in demotion. So in his head, he's thinking this, again, considering that only the Category 3 can result in demotion, he is suggesting or implicitly saying there that this had to be a Category 3, either one. And Category 3 itself also anticipates this scenario where it says if it's an issue within a lower category of offenses with repetitive offenses or aggravating circumstances, and considering this was Deputy Duncanson's second failure to closely monitor his subordinates, even if that would have been found within the explanation for Category 2, right, the justification there is that it's actually Category 3 in this instance. There's also two examples which are non-exhaustive, but one would be example B under Category 3, and again, this is on page 15 of the policy. And if you think it's difficult to read as judges, imagine trying to advise on this. So Section B says failure to take corrective action when warranted. That would certainly apply to the child custody offense. This was an employee that took a child out of a parent's home without a warrant. It's a violation not only of the Fourth Amendment, which of course is serious enough, but it's so egregious that there's an entire policy on how to serve these types of warrants, an entire section of the sheriff's office that serves them. And so any supervisor that finds that written into an incident report would be expected to take some corrective action. And then subsection D says failure to report improper activity or violation of a policy or procedure to a supervisor. Of course, he is the supervisor, and this would be a scenario where it may even need to get kicked up the chain of command one more time on this deputy. And so all of that from the discipline policy, in addition to the predetermination hearing worksheet, and really crucially, Chief Lopez's testimony that this offense by itself would justify demotion, demonstrates that it's a Category 3 and that the demotion was warranted. Again, because if you're looking on page 11, it's a second offense. Again, we've already talked about the prior. And if it's a Category 3, you can have up to an 80-hour suspension. There's nothing in the record and nothing in the policy that dictates where on either banks of the minimum and maximum river the appointing authority has to land.
Well, and Juarez, I think, teaches us that if it's within the range, it's going to be a difficult and rare case that would warrant changing that.
Yes, Your Honor, that's exactly right. Juarez talks about in the footnotes how that might be a way you could demonstrate arbitrariness, either through comparators or, and again, I have to imagine that, you know, the grave acts exception would be another example where deviating from that would be contemplated in the policy, but that's certainly for another day because, as counsel pointed out, this wasn't a grave act. It was simply a continuation of what transpired before. Counsel brought up the idea of remand, the necessity for remand. Again, it's just not necessary here. Perhaps we could kick it back down. The court could kick it back down, to sort of clean up this second offense. There's nothing to clean up about the first offense, and it would simply be a waste of judicial resources and a waste of the Merit Commission's time when they've set the stage for everything else. There's the Ferentz case that was cited in the answering brief, which I recognize is not entirely on all fours because it's slightly different when you're dealing with these sorts of administrative bodies that are commissions rather than, a administrative body that has some kind of expertise, which I think is the flaw in in Duncanson's argument that there needs to be some sort of heightened administrative deference given toward the Merit Commission. Again, they don't have any expertise on law enforcement. That's not what they're established for by statute. They're there to serve as a backstop to make sure that county agencies are properly going through progressive discipline, following their discipline policy, and giving due process to employees who are going to be lose some sort of a property interest. And so the Ferentz case talks about where if they've done everything, and I guess it's indisputed at this point that they've done everything with respect to the child custody case. They found the facts. They have the conclusions of law. It's just that last little bit, that last conclusion to uphold. This court and the Superior Court do not need to remand it back down for them to fix any kind of ancillary matters. Unless the court has any other questions or concerns about the traffic stop offense, because I don't want to. Our focus today has been, of course, on the child custody offense, but I don't want the court to think that we're waiving any argument that Chief Lopez was justified in finding discipline was warranted for the traffic stop offense either, and that Fact 18 is really an apposite. I'm going to go ahead and take my seat.
Thank you, counsel.
Thank you.
Mr. Rowanchek.
There's a couple things I'd particularly like to address. First of all, I'm concerned that we don't want to make the same mistake that Superior Court did in starting to reweigh facts and reweigh determinations of evidence. This question about whether it was discretionary for him to do what he did, that was a finding of fact basically as to whether he was put on notice of it being misconduct. Without getting the details of what his incident was about, I mean, a simple comparison would be, let's say somebody was disciplined for not having weekly meetings. You know, a sergeant who doesn't have weekly meetings. Obviously, the question there is, well, is there something that says he has to have weekly meetings? Is there some rule about that? Is he put on notice, as a matter of fact, that that would be misconduct? So here, that's what the commission found. It found that, you know, his particular instance was there was a woman being put into a vehicle by two other deputies who he was there standing back from. And he was on the phone with the MCSO asking about a question of law. She'd given a fake ID. He wasn't sure if it was real or not, basically, as a matter of law. Because it was a sovereign citizen ID, she claimed. He didn't know if that had some legal authority. So he was standing back, and what the MCSO criticized him for was not being close enough. And that's where you've got this comment that, well, that's discretionary, because he could stand back to watch the scene, make sure nobody's approaching, or if she somehow gets away and makes a run for it, he's in a better position to catch her and intercept her at that point. And we've already got two guys there who are handling this woman. So that's what this discretionary comment is. It cuts directly in his favor, because you've got the commission there saying he's not on notice, which is one of the requirements to find discipline under the Just Cause statute. He's not on notice that this is somehow something that could warrant discipline. That's the first factor under Just Cause. So it's not this just finding that, well, you know, this is all in the discretion of the MCSO. Not at all. They're saying that's a discretionary call there, what to do in that situation. Therefore, he's not on notice that what he did was wrong.
What about Mr. Bronco's contention that, setting aside the traffic incident, the child custody incident standing alone given the findings of fact by the commission, and if you assume that it falls within Category 3, is sufficient?
Yeah, that was my number 2. Thank you. So he's right to focus on that first paragraph on page 2 of the policy, because that's what the commission did as well. And the commission member's question was about, it says here, lesser discipline should generally be imposed first, unless the misconduct is of a more grievous nature. And prior to that, it talks about how grave acts, i.e., you know, acts of a grievous nature.
If we accept that this was not a grave act, and we go back to prior discipline, what we've heard is there was prior discipline. How do you get around that issue?
Correct. So that puts us in column number 2 here in that chart on page 11. He was a non-exempt regular status employee. It puts us in the second column. That's the significance of that, which is for a second offense. But even then, and even for number 3, again, we've heard this could be number 2/3. The maximum for number 2 is a 32-hour suspension. The maximum for number 3 is an 80-hour suspension. That's the maximum, not even a demotion. So there's this note about...
Except we have then at the
Right.
bottom, demotions may be considered
Right.
for personnel whose conduct falls into discipline level equivalent to 80 hours of suspension.
Right.
So
where it's of a grievous nature. That's where that
where
second
does it
paragraph.
say that?
That's the meaning of paragraph 1 here, as the commission interpreted it, because otherwise, what is there to justify the maximum? It says that unless the conduct is of a more grievous nature, lesser discipline should be imposed first, which in this case would be the minimum. For number 3, it's an 8-hour suspension. For number 2, it's an 8-hour suspension. Again, the maximum here strictly is an 80-hour suspension, so to impose something beyond that, under this note, clearly it has to be of a grievous nature. So that's why the commission focused on that.
How do you square that with Juarez, though? That Juarez basically says, I'm paraphrasing, as long as it falls within the range of permissible discipline, it's going to be the rare and unusual case where here the commission could quibble with the discipline imposed.
Because they concede it's not a grievous act. And only a grievous act can you have the maximum discipline. It says only if the misconduct is of a more grievous nature, unless it's of a grievous nature, lesser discipline should be imposed first.
Category 3 doesn't talk about grievous acts. I mean, some of the later categories do, but Category 3 is clearly something less than a grievous act. Conduct that has a pronounced negative impact on the operations or professional image, or an issue within a lower category with repetitive offenses.
Correct, and that's why it states it's an 80-hour suspension maximum. What the Commission interpreted this to mean is where you have that footnote, it says, well, demotions may be considered for an 80-hour suspension. It means under those grievous circumstances. Only that's when you consider the maximum. Otherwise, you should impose the lesser discipline. And it's outside the matrix. If for something they admit is something warranting lesser discipline, i.e. not a grievous act, they went ahead and imposed the discipline for a grievous act. That's the distinction there, and that's why the Commission focused on that. And again, we even have these statements from the Commission members saying, I don't find this is a grievous act, and they continue to concede that. And therefore, it's outside the chart. It's arbitrary and capricious.
Why didn't they make that finding? There was that discussion, I'll give you that, but they never made that finding that it was outside the matrix.
You know, and I think we have to concede that they could have done a better job with the way they wrote this ruling up. So
We'd all agree on that.
all the lawyers in the room agree, which is rare. But I think, again, that clearly the remedy for that is not simply to reverse. It's not simply to affirm the Superior Court, which likewise just summarily reversed because it was unclear. Again, that's not the proper standard here of deference to the Commission. We should allow them to clarify their findings of fact if there's such a level of lack of clarity. And the findings of fact that they made, again, including that it was not grievous and that sort of thing, to support that it was outside of the matrix. Again, I'm making these arguments today based on their oral comments during deliberations. But, you know, it's hard not to concede that it would be nice to have a clear order here and that there would be a proper basis on which to remand to the Commission to allow them to do that. So otherwise, you know, we have this issue of Chief Lopez allegedly saying that either offense would qualify. That's a credibility determination for the Commission to make. His testimony that either offense would warrant the demotion, it's inconsistent with the chart.
When you say allegedly made, he actually made the statement.
Right, so I mean, he did. So his statement that allegedly, I put the allegedly in
I wanted
there.
to make sure you weren't contesting that he made the statement.
No, he did make that statement. He did testify to that. But the point is that the Commission is entitled to disregard that completely, to find he was not credible on that. That's, again, a credibility determination the Commission makes, and that it's entitled to deference on. So, you know, we believe that, if nothing else, this Court should remand, but candidly, there was a basis in their oral comments that we've talked about on which to affirm the Commission, that they did find it was outside, given the admission that it was not a grievous act, that it was outside of the chart, and they only found that half of the actual conduct occurred. And again, their factual findings are entitled to deference. There's this little issue floating around about the subject vehicle. They obviously know what they were talking about, whether the subject was the deputy or the subject was the person being arrested. That's just, you know, imprecise language, clearly. But again, one more thing that they could clarify. So I see my time is running out fast here. Unless the Court has further questions, that's it for me.
No, I don't think so.
Thank you.
Councilor, thank you both for your arguments this morning. The Court will take this matter under advisement and issue a decision in due course. Thank you.